Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's lecture, we are going to discuss Bharatiya Sakshya Adhiniyam section number 7 to 14. Let's get started.
All right, today we're going to unlock a really fundamental piece of trial law. Section 7 of the... You can think of it as the ultimate gatekeeper in a courtroom. It's the rule that decides which pieces of the puzzle actually get to be seen by the court to build that bigger picture. So let's dive in. Here's the roadmap for this explainer. We'll start by understanding why a court can't just look at any and every fact. Then, we'll get into the weeds of Section 7 itself. After that, we'll explore its most famous real-world application, the identification parade, and look at some key court rulings that have shaped it. And finally, we'll wrap it all up with the single most important takeaway from this powerful law.
So let's kick things off with a basic problem courts face. In any legal case, there's just this ocean of information, but a court can't possibly consider everything. It would be total chaos and trials would never end. The law needs a filter, right? Well, Section 7 is that filter. It lets in facts that are necessary to explain or introduce the main issues of the case. It basically says that context isn't just a nice-to-have, it's absolutely essential.
Okay, now let's get down to the nitty-gritty and look at the law itself. We're going to break down the actual language of Section 7 to see exactly what kinds of contextual facts it considers relevant. And then we'll walk through the official illustrations that really bring this legal text to life.
You'll notice the language here is incredibly broad, and that's on purpose. It covers facts that explain or introduce something, facts that support or push back against a theory, facts that establish someone's identity or pin down a time and place, and facts that show the relationships between people. This wide scope is what allows the court to take abstract circumstances and turn them into concrete, admissible evidence. Let's see how the examples make this clear.
Let's start with a dispute over a will. Now, to figure out if a will is genuine, you can't just look at the document in isolation, right? You have to understand the world of the person who wrote it. How much property did they own? What was their family situation like? All these background details are crucial because they explain the circumstances surrounding the will's creation.
Okay, now imagine a libel case, which is all about written defamation. The pre-existing relationship between the two parties is hugely relevant. Were they friends who had a falling out? Were they fierce business rivals? This kind of information introduces the core issue and helps explain potential motives. It gives the court a narrative to follow. This one is really interesting. Let's say an accused person flees right after a crime. That looks pretty bad, doesn't it? It suggests guilt. But Section 7 ensures the court gets a balanced view. If that person can show they had to leave for, say, a sudden and urgent business trip, that fact becomes relevant because it rebuts the inference of guilt. It offers another, perfectly innocent explanation for their behavior.
Here we see how someone's words can explain their actions. Say a company is suing a rival for poaching a key employee. Well, what that employee said when they were leaving, something like, "I'm leaving because B made me a much better offer," that statement becomes a relevant fact. It directly explains their conduct, which is the heart of the case.
Picture this. You see someone handing over a package of stolen goods. The physical act itself is suspicious, of course, but it's the words spoken during the act that really explain what's going on. A statement like, "A says you are to hide this," that changes everything. It transforms a simple handover into a conspiracy to conceal a crime.
And for our last illustration, think about something as chaotic as a riot. Proving someone was marching at the front of a mob is one thing, but what was the mob shouting? What were their cries? Were they chanting for peace, or were they inciting violence? Those collective shouts are relevant under Section 7 because they reveal the true nature and intent of the entire event.
So all these examples bring us to one of the most critical and frequently used applications of Section 7, establishing a person's identity. This is where the law gets very practical, through a procedure you've probably heard of, the test identification parade.
So what exactly is an identification parade? Well, it's a formal process that police use when a witness says they saw the person who committed a crime, but they didn't know them beforehand. The police will line up the suspect with several other people who look similar, and they'll ask the witness to pick out the person they saw.
Now here is the absolutely crucial point to understand. This parade is not, in itself, substantive evidence of guilt. It's what we call a tool for corroboration.
It's there to test how reliable the witness's memory really is, and it gives the investigator some assurance that they're pursuing the right person. Its main job is to add weight and trustworthiness to a later identification that happens in the courtroom.
And this isn't just a theory, it's a principle that's been clearly laid out by the Supreme Court of India. In the case of M.D. Kalam versus the state of Rajasthan, the court specifically said that the purpose of the parade is to help the investigating agency make sure it's on the right track. It's a vital check and balance within the investigation itself.
So, the law gives us the framework, but over the years, the courts have had to build a set of rules to make sure these identification parades are conducted fairly and that their results are actually reliable. Let's dig into some of the most important judicial precedents that have been established.
The judiciary has come up with several key principles to ensure fairness. First, timing is everything. The parade has to happen pretty quickly after the event. Second, an identification made in court can still be powerful, even if there's been a long delay. Third, and this is just common sense, if the witness already knows the accused, there's no point in a parade. And fourth, and this one is critical, if the suspect's identity is shown to the witness beforehand, the whole parade loses its value.
And these principles all come from landmark cases. In State of UP versus Subraj Raj, a delay of 5 years was called inordinate and it made the identification totally unreliable. But on the flip side, in Daya Singh versus the state of Haryana, an ID made in court 7 years later was considered reliable, which shows you the power of testimony right in front of a judge. In Yakub Patel versus the state of Gujarat, the court confirmed that, yep, if the witness knows the guy, a parade isn't mandatory. And finally, in Chandan versus the state of Rajasthan, the court made a huge ruling for the modern age. If a suspect's photo is blasted all over the media before the parade, the procedure is basically worthless.
So, after looking at the text, the illustrations, and all these court cases, what's the bottom line? What's the one big idea we should really take away from Section 7?
It all boils down to this. Facts never, ever stand alone. An action, a statement, or even a person's identity can only be truly understood when you see all the circumstances surrounding it. Section 7 is the law's way of saying that context isn't just helpful, it is absolutely essential for finding the truth and making sure justice is done.
You know, this law was written way back in 1872, but it is more relevant today than ever. And that leaves us with a final, really interesting question to think about in our digital age. With the explosion of CCTV footage, location data, and social media trails, what are the new, complex forms of context that our courts are going to have to grapple with under Section 7 in the years ahead?
Section 10 of the Indian Evidence Act is now Section 8 of the Bharatiya Sakshya Adhiniyam.
Section 10 of the Indian Evidence Act. This is the rule that lets the words and actions of one person be used against another in a conspiracy, even if they've never even met. So let's get right into it. So let's kick things off with a question that really gets to the heart of it all. Imagine this. Can you be found guilty of a crime because of something your partner did or something they said, even if you weren't there? You might not have even known about it. It sounds kind of crazy, right? But this is exactly the kind of situation the law of conspiracy was designed to handle. Okay, so here's our game plan. First, we'll look at why it's so incredibly hard to prove a conspiracy in the first place. Then we're going to decode Section 10 itself. We'll unpack the logic behind it, this thing called the theory of agency. Then we'll see it in action with a real Supreme Court case. And finally, we'll wrap it all up with the key takeaways.
So let's dive right in with the biggest problem here. A conspiracy, at its core, is a secret agreement to do something illegal. But that's the whole issue, isn't it? How on earth do you prove an agreement that was specifically designed, from the very beginning, to be completely hidden from view?
I mean, just think about it. People don't form conspiracies in boardrooms with signed contracts and minutes. No way. They're hatched in whispers in the shadows. And because getting direct proof is next to impossible, the law needed to figure out a way to work backwards, to use the actions of the conspirators themselves to prove that the secret agreement even existed at all.
And that brings us right to Section 10 of the Indian Evidence Act. This is the law's very specific, and I have to say, very powerful solution to this exact problem.
Okay, let's look at the actual wording here. It says that once there's a reasonable ground to believe a conspiracy is going on, then anything said, done, or written by any one of them, as long as it's to push the plan forward, becomes a relevant fact against every single person involved. Now, this is a huge deal. Let's break down the 4 critical conditions that have to be met.
This rule isn't just a blank check for prosecutors. There are 4 strict conditions. First off, you need some initial evidence, what lawyers call a prima facie case, to even suggest a conspiracy exists. Second, the action or the statement has to come from one of the co-conspirators. Third, and this is absolutely key, it has to be done to further the group's common intention, their shared goal. And finally, it has to happen while the conspiracy is still ongoing.
And the scope of this rule? It is just staggering. Once those conditions are met, that piece of evidence can be used against everyone in the plot. It can be used to prove the conspiracy exists in the first place and that a specific person was part of it. Think about that. You can be implicated by the actions of someone you've never even met for something you knew absolutely nothing about.
So you're probably asking, wait a minute, how is that fair? How can one person's actions legally bind somebody else in a criminal case? Well, to understand that, we need to look at the legal principle that makes this whole thing work. The theory of agency.
To make this work, the law creates something called a legal fiction. It basically pretends that when you join a conspiracy, you're appointing every other member as your agent. So, just like a business owner is responsible for what their employees do on the job, in a conspiracy, the act of one person legally becomes the act of everyone.
This slide makes the analogy crystal clear. In the business world, if you hire an agent to act for you, their actions bind you, the principle. It's your responsibility. In a conspiracy, the authorization is simply the agreement to work towards that common goal. So when one conspirator does something to move that goal forward, they are, in the eyes of the law, acting on behalf of all the others, binding them to that act.
Okay, theory is one thing, but let's see how this actually plays out in a real courtroom. We're going to dive into the landmark Supreme Court case of Badri Rai versus the state of Bihar. It is a perfect textbook illustration of Section 10 in action.
So the facts of the case, they're actually pretty simple. A goldsmith named Ramji gets arrested with stolen gold. Then his neighbor, a man named Badri Rai, gets involved and tries to bribe the police inspector to just, hush up the case.
Let's walk through the timeline of what happened. It starts on August 22nd, when Ramji is arrested. Just 2 days later, on the 24th, both Ramji and Badri Rai go together to see the inspector and offer him money. Then, a week after that, on August 31st, Badri Rai goes to the police station by himself and actually pays 500 rupees, saying it's on behalf of Ramji to make the case go away. And this right here, this is the million-dollar question for the court. Ramji wasn't there on August 31st. He didn't hand over any cash. So the question is, could the words and actions of Badri Rai, who was acting alone that day, be used as evidence to convict Ramji of conspiracy? Well, the Supreme Court's answer was a resounding yes. It ruled that since Badri Rai's payment was made to further their common intention of hushing up the case, it was absolutely admissible as evidence against Ramji under Section 10. Even though Ramji wasn't physically there, his partner's action was legally considered his action. Okay, so we've covered the law, we've looked at a real case. Let's boil all this down to the most important things you really need to remember from all of this. So let's lock in these key takeaways. Number 1, Section 10 is an exception, a special rule designed to fight secret plots. 2, it all runs on the theory of agency, which says each member acts for all the others. 3, this means the act of one person really does become the act of all. 4, the absolute non-negotiable rule is that the act must be about achieving their shared goal. And finally, remember, the clock is ticking. Once the conspiracy is over, Section 10 just doesn't apply anymore. And this leaves us with a really critical question to think about. There's no doubt Section 10 is a powerful weapon against criminal networks, but it comes with a serious risk, the risk of convicting someone based on what other people did, things they might not have ever even known about. So, does this law strike the right balance between justice and fairness? It's a tough question, one that courts and lawyers still grapple with every single day.
आज हम जुडिशरी एग्जाम्स के लिए एक बहुत ही क्रूशल लीगल कॉन्सेप्ट को ब्रेक डाउन करेंगे, द प्ली ऑफ एलिबी। आज के इस डिस्कशन में हम 5 की एरियाज कवर करेंगे। सबसे पहले हम सेक्शन 9 का इंट्रोडक्शन देखेंगे, फिर समझेंगे कि प्ली ऑफ एलिबी आखिर होता क्या है, इसको कोर्ट में प्रूव कैसे करते हैं, कुछ इंपॉर्टेंट सुप्रीम कोर्ट रूलिंग्स पर नजर डालेंगे और एंड में आपके एग्जाम्स के लिए कुछ जरूरी रिवीजन पॉइंट्स डिस्कस करेंगे। तो चलिए शुरू करते हैं इस कॉन्सेप्ट की लीगल फाउंडेशन से। आज हम डिस्कस करेंगे सेक्शन 9, यही वो स्टार्टिंग पॉइंट है। ओके, ये जो लीगल लाइन आप स्क्रीन पर देख रहे हैं, यही इसका कोर है। ये कहता है कि वो फैक्ट्स जो शायद केस से डायरेक्टली रेलेवेंट ना लगें, वो भी रेलेवेंट हो जाते हैं। कब? जब वो केस के किसी मेन फैक्ट या फैक्ट इन इशू से इनकंसिस्टेंट हो, यानी उसके अचानक अगेंस्ट चले जाएं। सिंपल भाषा में अगर कोई इन्फॉर्मेशन प्रोसिक्यूशन की मेन स्टोरी को डायरेक्टली कॉन्ट्रडिक्ट करती है, तो वो इन्फॉर्मेशन अचानक से बहुत इंपॉर्टेंट एविडेंस बन जाती है। और इनकंसिस्टेंट फैक्ट्स का यही प्रिंसिपल एक बहुत ही कॉमन और पावरफुल डिफेंस स्ट्रैटेजी को जन्म देता है। और इसी से हम आते हैं अपने अगले पॉइंट पर। आखिर ये प्ली ऑफ एलिबी है क्या? देखिए, एलिबाई एक लैटिन वर्ड है जिसका मतलब होता है एल्सवेयर, यानी कहीं और। जब कोई अक्यूज्ड पर्सन इस डिफेंस को यूज करता है तो वो एक सिंपल सी बात कह रहा होता है, मैं ये क्राइम कर ही नहीं सकता क्योंकि जब ये क्राइम हो रहा था मैं तो उस जगह पर था ही नहीं, मैं कहीं और था। ये एक ऐसा डिफेंस है जो फिजिकल इम्पॉसिबिलिटी पर बेस्ड है। चलिए एक एग्जाम्पल से इस कनेक्शन को समझते हैं। मान लीजिए फैक्ट एंड इशू है, क्या ए ने रात 8 बजे पुणे में क्राइम किया? अब ए एक फैक्ट प्रेजेंट करता है, मैं तो उस वक्त दिल्ली में था। अब देखिए, ए का दिल्ली में होना उसी टाइम पर पुणे में क्राइम करने के फैक्ट से बिल्कुल इनकंसिस्टेंट है। इसीलिए सेक्शन 9 के तहत ए का दिल्ली में होना एक हाईली रेलेवेंट फैक्ट बन जाता है।
लेकिन कोर्ट में बस ये कह देना कि मैं वहां नहीं था काफी नहीं होता। कोर्ट चाहती है कि इस प्ली को ठीक से प्रूव किया जाए। और यहीं पर आती है सबसे जरूरी बात, इसको प्रूव करने का बर्डन किसके ऊपर है और इसकी रिक्वायरमेंट्स क्या हैं। यहाँ पर प्रूफ के 2 अलग अलग स्टैंडर्ड्स हैं। प्रोसिक्यूशन के ऊपर केस को बियॉन्ड रीजनेबल डाउट प्रूफ करने का भारी बोझ होता है, लेकिन जब अक्यूज्ड प्ली ऑफ एलिबाई लेता है तो ये बर्डन उस पर शिफ्ट हो जाता है। अक्यूज्ड को अपना एलिबाई प्रिपॉन्डरेंस ऑफ प्रोबेबिलिटीज के बेसिस पर प्रूफ करना होता है। ये एक लोअर स्टैंडर्ड है। इसका मतलब बस ये है कि अक्यूज्ड को ये दिखाना है कि इस बात की संभावना ज्यादा है कि वो कहीं और था। एक एलिबी को कोर्ट में वैलिड मानने के लिए ये 4 एसेंशियल रिक्वायरमेंट्स पूरी होनी चाहिए। पहला, आपका क्लेम स्पेसिफिक होना चाहिए, वेग नहीं। दूसरा, आपको प्रूव करना होगा कि आप एक स्पेसिफिक अलग जगह पर मौजूद थे। तीसरा, वो जगह क्राइम सीन से इतनी दूर होनी चाहिए कि आपका वहां से आकर क्राइम करना फिजिकली इम्पॉसिबल हो। और आखिरी, आपके क्लेम के सपोर्ट में रिलायबल एविडेंस होना चाहिए, जैसे टिकट्स, सीसीटीवी फुटेज या भरोसेमंद गवाह। तो अब थ्योरी तो हमने समझ ली, पर चलिए देखते हैं कि सुप्रीम कोर्ट ऑफ इंडिया ने इस इम्पॉर्टेंट डॉक्ट्रिन को कुछ लैंडमार्क केसेस में कैसे इंटरप्रेट और अप्लाई किया है। इन जुडिशियल इंटरप्रिटेशंस को समझना आपके एग्जाम्स के लिए बहुत जरूरी है। एक प्रैक्टिकल एग्जाम्पल लेते हैं। मान लीजिए मुंबई में रात 9 बजे एक रॉबरी होती है। अक्यूज कोर्ट में उसी टाइम का बेंगलुरु का एयरलाइन टिकट, बेंगलुरु एयरपोर्ट का सीसीटीवी फुटेज और वहां के होटल का चेक इन रिकॉर्ड पेश करता है। ये एविडेंस साफ साफ एस्टैब्लिश करता है कि उसके लिए मुंबई में होना फिजिकली इम्पॉसिबल था। ये एक सक्सेसफुल एलिबाई का क्लासिक एग्जाम्पल है। इस टॉपिक पर शायद सबसे इंपॉर्टेंट केस है विनय कुमार सिंह वर्सेस स्टेट ऑफ बिहार 1997 का। इस केस में सुप्रीम कोर्ट ने एक बहुत ही क्रूशियल प्रिंसिपल एस्टैब्लिश किया। अगर कोई अक्यूज्ड अपना आलिबाई प्रूफ करने में फेल भी हो जाता है तो इसका मतलब ये नहीं कि वो ऑटोमेटिकली गिल्टी हो गया। केस को बियॉन्ड रीजनेबल डाउट प्रूफ करने का बर्डन हमेशा प्रोसिक्यूशन पर ही रहता है। 2 और इम्पॉर्टेंट रूलिंग्स हैं जो इसमें और डिटेल्स ऐड करती हैं। दूतनाथ पांडे के केस में कोर्ट ने कहा कि अगर एलिबाई झूठा साबित होता है तो ये अक्यूज्ड के खिलाफ एक एडिशनल इंक्रिमिनेटिंग सर्कमस्टेंस माना जा सकता है। और स्टेट ऑफ हरियाणा वर्सेस शेर सिंह में कोर्ट ने इस बात पर जोर दिया कि एलिबाई की प्ली को क्रेडिबल मानने के लिए उसे केस की शुरुआत में यानी अर्लीस्ट पॉसिबल स्टेज पर रेस करना चाहिए। तो हमने कॉन्सेप्ट भी कवर कर लिया और केस लॉ भी। अब आते हैं सबसे जरूरी हिस्से पर, आप सब एस्पिरेंट्स के लिए एग्जाम फोकस्ड और एक क्विक रिविजन। इस पर जरूर ध्यान दें। जुडिशरी प्रीलिम्स और मेंस दोनों के लिए ये सेक्शन बहुत इंपॉर्टेंट है। प्रीलिम्स में सेक्शन नंबर या केस लॉ पर डायरेक्ट क्वेश्चन आ सकता है और मेंस में एक डिटेल्ड एनालिटिकल क्वेश्चन बन सकता है। एपीओ एग्जाम के लिए भी ये एक हाई प्रोबेबिलिटी टॉपिक है।
तो चलिए एकदम जल्दी से रिवाइज कर लेते हैं। 3 बातें हमेशा याद रखें। पहला, इसका लीगल बेसिस है सेक्शन 9 ऑफ। दूसरा, कोर कॉन्सेप्ट है प्ली ऑफ एलिबाई, यानी कहीं और अपनी प्रेजेंस प्रूफ करके क्राइम की फिजिकल इम्पॉसिबिलिटी दिखाना। और तीसरा, इसको प्रूफ करने का बर्डन एक्यूज्ड पर है और स्टैंडर्ड है प्रिपॉन्डरेंस ऑफ प्रोबेबिलिटीज।
और इसी के साथ प्ले ऑफ एलिबाई पर हमारा ये डिस्कशन यहाँ खत्म होता है। हम उम्मीद करते हैं कि ये ब्रेकडाउन आपकी एग्जाम प्रिपरेशन में मदद करेगा।
So, have you ever wondered how a court actually puts a price tag on someone's pain and suffering? Or how does an ancient tradition, something that's never been written down, suddenly get treated like an actual law? Well, today we're diving into two incredibly important pillars of India's new Evidence Act that are designed to answer those exact questions. At first glance, these seem like they're from totally different worlds, right? One is deeply personal. It's about one person's physical harm. The other is about an entire community's unwritten rules, stuff that's been passed down for generations. But here's the thing. A fair and just legal system has to have a solid way to handle both. And that's exactly what we're going to explore today. So we're taking a look at the brand new Bharatiya Sakshya Adhiniyam 2023. And don't worry about the name. Sakshya literally just means evidence. We're going to frame this whole thing around what I'm calling the two pillars of fair judgment to see how a couple of key sections in this new act work together to support the entire structure of justice in these tricky situations. All right, let's get into our first pillar. This is all about the individual. It's built to answer a really fundamental question. When someone gets hurt, how does a court figure out what's fair compensation? I mean, how do you even begin to put a rupee value on loss and suffering? The legal engine driving this whole process is Section 10, and what I love about it is how refreshingly simple the language is. It basically says, if you're in court claiming damages, then literally any fact that helps the judge figure out the right amount of money is relevant evidence. The whole point is just to land on a number that's fair and just. Simple as that. And just look at how broad this is. It's not just about the obvious things you can put a receipt to, like medical bills or the salary you lost. The law makes it clear. The court has to look at the invisible damage, too. We're talking about mental suffering, harm to your reputation, how this might affect your future. It forces the court to see the whole picture, the total impact on a person's life. And all of this brings us to this really foundational legal idea. It's a Latin phrase, restitutio in integrum. Now, I know it sounds super academic, but its meaning is actually very simple and really powerful. The goal of all this compensation is to restore the person to the position they were in before the harm happened, as much as money can possibly do that. This really breaks it down perfectly. The court has to weigh two kinds of losses. On one side, you've got pecuniary losses. These are the tangible things, the stuff with a clear price tag, like doctor's bills. But on the other side, you have the non-pecuniary losses, and this is the intangible stuff, like pain, suffering, or just not being able to enjoy life the way you used to. A truly fair judgment has to balance both sides of the scale. And let me be clear, this isn't just some theory from a law book. This principle was made rock solid by the Supreme Court in the famous R.D. Hattangadi case. The court's ruling was crystal clear. You simply cannot ignore pain and suffering. It's an absolutely fundamental part of trying to make that injured person whole again. Okay, let's shift gears and move over to our second pillar. Here, we zoom out from the individual's harm to the rights of a whole community. We're talking about those unwritten rules and traditions that people have been following for so long that they've basically become the law for that group. This is where Section 11 steps in. It gives the court a roadmap to answer the big question. Is this particular tradition a legally binding custom? And what it says is that any evidence showing a history of this custom, whether it's being created, fought over, or just plain used, is relevant for the court to consider. But hold on, not just any old tradition gets to be called a law. The Supreme Court has laid out a very strict four-part test. For a custom to be legally valid, first, it's got to be ancient. Second, its rules have to be certain and clear, not fuzzy. Third, it has to be reasonable, so it can't be unjust. And finally, and this is a big one, it must have been followed continuously, without any major breaks. This leads us to another one of those powerful Latin maxims, consuetudo est altra lex. It literally means custom is another law. Think about that. When a tradition manages to pass all four of those tough tests, it gets the same power and force as a law passed by Parliament. It's this incredible recognition that law doesn't just flow from the top down. It can bubble up from the ground, from the way communities have lived for centuries. The key thing to remember here is that the burden of proof is incredibly high. You can't just walk into a courtroom and say, hey, it's our tradition. Nope. You have to back it up with clear and convincing evidence. We're talking historical documents, real-world examples, and a clear pattern of use over time. So, we've looked at our two pillars, one dealing with individual compensation, the other with collective customs. So what? Why is it so crucial for our legal system to have both of these tools in its toolbox? This table just sums it all up perfectly. Section 10 is zoomed in. It's micro-focused on the individual, using hard evidence like receipts to try and make that person whole again. Section 11, on the other hand, is zoomed out. It's macro-focused on the community, using historical evidence to give legal muscle to a tradition. They are two totally different, but equally vital instruments for justice. And all of this leaves us with a huge question, especially for a rapidly modernizing India. As society changes, how do we strike the right balance? How does a court weigh the very real, provable harm done to one person against the ancient traditions of an entire community? Look, there is no easy answer here, but it's a fundamental challenge that these two pillars will help our courts navigate for many, many years to come.
Hello everyone and a very warm welcome to Ganga Education. For all you judiciary and APU aspirants out there, आज हम लॉ ऑफ एविडेंस का एक बहुत ही इंटरेस्टिंग, बहुत ही फैसिनेटिंग कॉन्सेप्ट डिकोड करने वाले हैं।
एक सवाल है आपसे, कभी सोचा है कोर्ट ऑफ लॉ में आप कोई ऐसी चीज कैसे प्रूव कर सकते हैं जो दिखती ही नहीं? फॉर एग्जाम्पल, किसी की नियत, उसका इंटेंशन, ये तो इनविजिबल है, राइट? वेल, ये एक फंडामेंटल क्वेश्चन है जिसका इंडियन लॉ के पास एक बहुत ही पावरफुल आंसर है। एक ऐसा प्रोविजन जो इस इनविजिबल स्टेट ऑफ माइंड को जस्टिस के लिए विजिबल बना देता है।
और वो प्रोविजन है सेक्शन 12 ऑफ द इंडियन एविडेंस एक्ट 1872। आज हम इसी को डिस्कस करने वाले हैं।
तो बेयर एक्ट क्या कहता है? देखिए, सेक्शन 12 कहता है, एंड आई कोट, facts showing the existence of any state of mind such as intention, knowledge, good faith, or showing the existence of any state of body or bodily feeling are relevant. बहुत सिंपल शब्दों में अगर इसको समझें तो इसका मतलब है कि अगर किसी केस में किसी इंसान की स्टेट ऑफ माइंड या उसकी स्टेट ऑफ बॉडी मैटर करती है तो उसको प्रूव करने वाले सारे फैक्ट्स कोर्ट में रेलेवेंट माने जाएंगे। सिंपल, राइट?
तो इस सेक्शन को ब्रेक डाउन करते हैं। इसमें 3 बहुत इंपॉर्टेंट चीजें। नंबर 1, स्टेट ऑफ माइंड यानी मानसिक स्थिति। इसमें क्या क्या आता है, जैसे कि इंटेंशन, नॉलेज या इलविल। नंबर 2, स्टेट ऑफ बॉडी यानी शारीरिक दशा। फॉर एग्जाम्पल, किसी की हेल्थ, कोई बॉडीली फीलिंग या जहर के सिम्टम्स। और सबसे इंपॉर्टेंट नंबर 3, ये जो स्टेट ऑफ माइंड या बॉडी है ना, ये उस केस में एक फैक्ट एंड इशू या रेलेवेंट फैक्ट जरूर होना चाहिए, तभी ये सेक्शन अप्लाई होगा।
ठीक है, थ्योरी बहुत हो गई। चलिए इसको एक प्रैक्टिकल एग्जाम्पल से समझते हैं। ये एग्जाम्पल सीधा बेयर एक्ट के इलस्ट्रेशन ए से ही लिया गया है। तो सिचुएशन ये है, मान लीजिए एक पर्सन है ए, उस पर आरोप है कि उसने चोरी का सामान खरीदा है और उसे ये पता था, ही हैड द नॉलेज, कि वो सामान चोरी का है। अब यहां पर सेक्शन 12 कैसे काम करेगा, सोच के देखिए। अगर पुलिस को ए के पास उस एक आइटम के अलावा और भी बहुत सारे चोरी के आइटम्स मिलते हैं तो ये फैक्ट सडनली बहुत रेलेवेंट हो जाता है। आप पूछेंगे क्यों? क्योंकि ये इस बात की तरफ पॉइंट करता है कि ए को नॉलेज थी कि ये सामान चोरी का है, वो कोई इनोसेंट बायर नहीं था। और इसी क्रिमिनल नॉलेज को हम लॉ में क्या कहते हैं? मेंस रिया, द गिल्टी माइंड। और बस यही तो सेक्शन 12 का पूरा कोर प्रिंसिपल है।
एग्जाम्पल तो समझ आ गया। अब इस सेक्शन को एक्शन में देखते हैं एक लैंडमार्क केस के थ्रू। ये सुप्रीम कोर्ट का एक बहुत ही इंपॉर्टेंट जजमेंट है। केस का नाम है दयाभाई छंगनबाई थक्कर वर्सेस स्टेट ऑफ गुजरात फ्रॉम 1964।
इस केस में सुप्रीम कोर्ट ने सेक्शन 12 के एप्लीकेशन को बहुत ही ब्यूटीफुली एक्सप्लेन किया है। लेट्स लुक एट द पॉइंट्स। पहला, अक्यूज ने अपने फादर इन लॉ को कुछ लेटर्स लिखे थे। कोर्ट ने उन लेटर्स को रेलेवेंट माना। क्यों? बिकॉज वो लेटर्स उसकी स्टेट ऑफ माइंड को शो कर रहे थे। उसकी अपनी पत्नी के लिए जो इलविल थी उसको दिखा रहे थे, जो कि मोटिव एस्टैब्लिश करने में हेल्प करता है। फिर दूसरा पॉइंट, डिसीज्ड की बॉडी की कंडीशन, इसको स्टेट ऑफ बॉडी प्रूफ करने के लिए रेलेवेंट माना गया, जिससे अटैक की ब्रुटैलिटी का पता चला। और तीसरा, डिसीज्ड की चीखें। ये सारे फैक्ट्स जब एक साथ आते हैं ना, तो उस पूरे इंसिडेंट की एक क्लियर पिक्चर क्रिएट करते हैं।
Okay, now for a very, very important update, especially for your upcoming exams. आपको ये जरूर याद रखना है कि जो नए कानून आए हैं, यानी भारतीय साक्ष्य अधिनियम 2023, उसमें सेक्शन 12 का जो कॉरेस्पॉन्डिंग प्रोविजन है, वो अब है सेक्शन 10। सो प्लीज इसे नोट डाउन कर लीजिए। ओल्ड लॉ सेक्शन 12, न्यू लॉ सेक्शन 10। तब सवाल उठता है कि एग्जाम पॉइंट ऑफ व्यू से ये सेक्शन इतना इंपॉर्टेंट क्यों है? देखिए, ये जुडिशरी प्रीलिम्स और मेंस दोनों के लिए ही क्रूशियल है। प्रीलिम्स में यू माइट गेट अ डायरेक्ट क्वेश्चन ऑन द सेक्शन नंबर, स्ट्रेट फॉरवर्ड। लेकिन मेंस में मेंस रिया पर बेस्ड एप्लीकेशन प्रॉब्लम्स आते हैं, जहां आपको इस सेक्शन को अप्लाई करना पड़ेगा। और हाँ, एपीओ एग्जाम में भी इस कॉन्सेप्ट से डायरेक्ट क्वेश्चंस आने की हाई प्रोबेबिलिटी रहती है। चलिए, तो एंड करने से पहले एक क्विक रिविजन हो जाए। 3 key takeaways. Number 1, we're talking about Section 12 of the Indian Evidence Act. Number 2, what's the core concept? It makes state of mind and state of body relevant facts.
Simple. And number 3, why is it important for exams? It's absolutely vital for proving mens rea in both your prelims and mains exams.
तो बस आज के लिए इतना ही. For more such judiciary-focused legal content, please stay connected with Ganga Education. All the very best for your preparations.
You know, have you ever stopped to think about how much your daily habits, your routines, how much they really say about you? Well, it turns out they can say enough to actually stand up in a court of law. So today, we're going to dive into the Indian Evidence Act to explore this fascinating idea, how courts use the patterns in our behavior to figure out the truth. Just look at this scene. You know, it could be a terrible, tragic accident, a simple moment of carelessness. But what if it wasn't? How on earth does a court distinguish between a one-off mistake and something deliberate? The answer, and this is what's so interesting, often lies not in this single moment, but in looking for a pattern. And that brings us right to our first major legal tool. We're going to see how a series of events that might seem totally separate, when you put them all together, can paint a really, really clear picture of what someone was actually thinking. So the key legal idea here is from Section 15 of the Indian Evidence Act. And it basically says this: if you're trying to figure out if something was an accident or if it was done on purpose, it is totally relevant to look at other similar things that happened involving that same person. See, a single incident, that could just be bad luck. But when it happens over and over, well, that starts to look a whole lot like a pattern of intent. This whole idea is brought to life perfectly by a classic example from the Act itself. It involves insurance and, well, a series of very, very unfortunate fires. Okay, so imagine this. A guy insures his house. A fire breaks out, and boom, he gets the insurance money. A real tragedy, right? But then he moves to a new house, insures it with a totally different company, and another fire happens. And then it happens a third time. The law says that this pattern, this series of fires, is crucial evidence. It helps to show that these fires were probably not accidental at all. Let's try another example, just to see how this works. What about something like counterfeit money? Imagine someone's accused of passing off a fake note. Now, they could easily claim it was just an honest mistake, right? That they had no idea it was a fake. Well, this is exactly where the pattern becomes the key. If you can show that the same person also passed fake notes to, say, 3 other people around the same time, suddenly their whole "it was an accident" defense starts to fall apart. The series of events makes it pretty clear they knew exactly what they were doing. Okay, so we've seen how patterns can prove someone's intention. But what about an even more basic question? Not why did they do it, but simply, did they even do it in the first place? How do you prove a simple action even took place? And this brings us to the second legal tool for today. Now here, we're not looking for a suspicious pattern of unusual events. Instead, we're looking for the comforting, predictable pattern of a well-established routine. Think about a really simple, everyday task: mailing a letter. If there was ever a legal dispute, how could you possibly prove that one specific letter was actually posted on a particular day? I mean, you're not going to remember that exact moment. The proof, it turns out, doesn't lie in your memory, it lies in the system. And this is the magic of Section 16. It's all about the ordinary course of business. So if a company has a standard procedure, like all outgoing mail goes into this specific tray, and it's a clerk's job to post those letters every single day at 5 p.m., then all you need to prove is that your letter was put in that tray. The law then presumes the system worked and the letter was posted. The routine itself, that becomes the evidence. So let's wrap this up and bring these two powerful ideas together. We've looked at 2 really different ways the law uses patterns to get to the truth, and each one answers a very different kind of question. So, to recap, nice and simple. For proving intent, was it an accident or was it on purpose? You look for a series of similar and often suspicious actions. But for proving a simple act, did this thing even happen? You look for a reliable, everyday routine and just show that the act was part of it. 2 kinds of patterns for 2 kinds of proof. Simple as that. And this leaves us with a really fascinating thought, doesn't it? These laws were written long before emails, before digital payments, before our whole world ran on algorithms. Today, our lives leave digital footprints absolutely everywhere. So the real question is, what new kinds of ordinary course of business or series of similar occurrences will courts look at tomorrow to find the truth in our digital habits? What will your patterns prove about you?
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.